Mr. Hollings, we need a word.
About what? I'm not sure what you need.
Marcus Hollings kept his own records of exactly what each client's plea was worth to him. Those records are now Exhibit A, and they're the reason he's being handcuffed by federal agents right now.
Payments from the Enslick Logistics was 22 clients, the Avenue F office, the green ink off ledger, handwritten ledger in green ink, 22 client initials, payment amounts, your own hand on every line.
I genuinely do not remember creating. I'm not going to say I did something.
He had spent 14 years telling other people to trust the system. He was about to find out exactly how the system handled the people who broke it from the inside. By October of 2024, federal agents had been listening to the Ensley Crew's logistics broker for nearly 6 months. They had pulled the caseload of every senior felony attorney in the Jefferson County Public Defender's Office. They had run the numbers, and the numbers told a story that no defense lawyer in Birmingham wanted to hear out loud. $342,000 in cash and gift cards, 22 clients, one handwritten ledger in green ink, locked inside the hollow base of a souvenir statuette on his desk. By the end of this story, Marcus Hollings would be inmate number 78443-001 at FCI Talladega, and 22 men he had personally walked into prison would be reading about him from their bunks. Before we go any further, I want you to think about something. The public defender is the one person in the courtroom whose entire constitutional job is to stand between you and the government. If you've ever sat across from one, or if you've ever wondered how often that job actually gets done right, drop a comment and tell me. And if you're not subscribed yet, now is the time. We cover cases the local news won't touch every single week. Marcus Demetrius Hollings was born in Birmingham, Alabama in May of 1980, the youngest of 3 children in a family that had lived in the Smithfield neighborhood for 4 generations. His father, Lonnie Hollings, was a millwright at the U.S. Steel Fairfield Works, who had walked the same picket lines his own father had walked in 1959. His mother, Verna, taught 3rd grade at Hayes K-8 for 31 years. The Hollings household was the kind of household where the rules were not explained because they did not need to be. You went to school, you came home, you did the work that was in front of you. Marcus was the quiet one. Teachers at Center Street Middle School wrote on his 6th grade evaluation that he was thoughtful, observant, and unusually patient with peers in conflict. At Ramsey High School, he made the debate team his sophomore year and stayed on it until graduation, winning a regional title his junior year, arguing the affirmative on a school search and seizure resolution. His coach later told the Birmingham News that Marcus was the only student she had ever taught who actually enjoyed reading appellate opinions. He went to Morehouse College in Atlanta on a partial scholarship in 1998. He worked the front desk at the campus library for federal work-study money and took the Greyhound home twice a month to do laundry. He majored in political science. He graduated in 2002 with honors and applied to 6 law schools. He chose the University of Alabama because his grandmother was sick and he wanted to be within an hour's drive of her house in Ensley. Law school was where he found the part of the work he loved. In his 2nd year, he joined the Capitol Defense Clinic and spent 2 semesters helping draft a habeas petition for a death row inmate at Holman Correctional Facility. The inmate's conviction was eventually vacated. The professor who supervised that clinic wrote in her recommendation letter that Marcus had the rare combination of analytical rigor and stomach for the work that Capitol Defense required. She encouraged him to apply to the Federal Public Defender's Office in Birmingham. Marcus chose state work instead. In June of 2010, he was hired as an assistant public defender in the Jefferson County Public Defender's Office, starting salary $46,000. He was 29 years old. His mother drove down from Birmingham and stood in the back of the swearing-in ceremony in a yellow dress and cried when he raised his right hand. The early years were the years his colleagues still talk about. He carried a felony caseload of over 200 clients almost from the first month, and he carried it well. His first jury trial in 2011 was a felon in possession case where the arresting officer's stop had been built on a description that did not match his client. Marcus filed a motion to suppress, won it at the hearing, and the case was dismissed before opening statements. He won his next 2 trials as well. By 2013, the office director was putting his name forward for the senior felony rotation, and by 2014, he was handling the narcotics docket alongside 3 other senior attorneys. He married Adrienne Caldwell, a pediatric nurse at Children's of Alabama, in the spring of 2013. They bought a small 2-bedroom house in the Crestwood neighborhood and had 2 daughters within 4 years. Colleagues remember the photo Marcus kept on his desk. Both girls in matching Easter dresses on the front porch, the older one holding a stuffed rabbit by one ear. He coached the older daughter's upward soccer team on Saturday mornings at the Eastwood YMCA. He took the family to Gulf Shores every August. He was, by every account anyone gave the FBI later, a man who had built exactly the life he had set out to build. His annual evaluations from 2011 through 2017 used 3 phrases over and over again: sound trial instincts, exceptional rapport with clients, strong candidate for future leadership within the office. No one looking at his file in 2017 would have predicted what was about to happen. To understand what Marcus Hollings did, you have to understand what a public defender is supposed to do. The Jefferson County Public Defender's Office, headquartered in the Mel Bailey Criminal Justice Center on Richard Arrington Jr. Boulevard, is one of the largest indigent defense offices in the state of Alabama. It serves roughly 14,000 criminal defendants every year. These are people who cannot afford to hire a private lawyer, people who, by constitutional right, under Gideon versus Wainwright, are entitled to representation paid for by the state. Most of those defendants are charged with misdemeanors. About 20% are charged with felonies. A smaller slice, the cases that come through the senior felony rotation Marcus worked on, are the major narcotics, weapons, and violent offense cases where the exposure runs into double-digit years. The math of public defense is brutal. The American Bar Association recommends that no single attorney handle more than 150 felony cases per year. Senior attorneys in the Jefferson County office routinely carry between 180 and 220 active felony clients at any given time. Each of those clients is, on paper, entitled to the same constitutional standard of representation, investigation, discovery review, motion practice, plea negotiation, and trial preparation that a paying client at a private firm would receive. In practice, what that means is triage. A public defender of Marcus Hollings' seniority would walk into the office on a Monday morning with a stack of police reports for clients he had not yet met, a calendar with 8 or 9 court appearances scheduled before noon, and a phone that started ringing at 8 and did not stop until 5. The work is impossible to do perfectly. Every attorney in that office knew it. The system depended on the attorneys filing the motions that mattered, fighting the cases that could be won, and pushing back on the ones where the state had overcharged. When a low-level drug case came in, a street-level dealer caught with grams instead of kilos, the kind of case where the state's evidence often had holes, a good public defender in that office knew what to look for. Was the traffic stop legitimate? Did the officer have probable cause to search the vehicle? Or had he relied on a hunch dressed up as a smell? Was the informant identifying the defendant the same informant whose credibility had been challenged in another courtroom down the hall? Was the lab certification for the seized narcotics current, or had it lapsed during the backlog? These were not exotic questions. They were the questions every public defender in the building asked, every week, on every drug case. And on a meaningful number of those cases, the answers led to suppression, to dismissal, to a plea on a much smaller charge. That was the chair Marcus sat in. The chair where, on the worst day of someone's life, the person across the table was supposed to be the one human being in the room who was on their side. The first envelope arrived in January of 2019. By that point, Marcus had been representing clients connected to the Ensley crew for about 3 years. The crew was a fentanyl distribution operation that had grown out of an older heroin network in the Ensley and Pratt City neighborhoods on the west side of Birmingham. By 2019, it was moving enough product through the Western Corridor that the DEA's Birmingham Field Division had opened a Title III wiretap investigation on the upper tier. The street-level workers, the runners, the corner men, the kids who carried the bags, were arrested constantly. Sometimes the cases got cleaned up by a private attorney the crew paid for. Most of the time, because the kids were broke, the cases got assigned to the public defender's office. Marcus had handled enough of them by 2018 that the crew's logistics broker, a man identified in the federal indictment only as co-conspirator 1, knew his name. The broker's job, among other things, was to manage the legal exposure of the organization's lower ranks. He approached Marcus in the courthouse cafeteria one afternoon in November of 2018 and asked if they could talk somewhere quieter. What was said in that conversation has never been fully reconstructed. What is known is that 2 months later, Marcus signed a 1-year lease on the second floor of 1417 Avenue F in the Ensley Business District, above a barbershop owned by the broker's uncle. He told his wife it was a quiet space to read transcripts away from the office. He told 2 co-workers the same thing. He paid the rent in cash, $450 a month, for the next 5 years and 8 months. The mechanism the federal indictment would later describe was simple and disciplined. When a low-level Ensley crew dealer was arrested, the broker would learn about it within hours, sometimes from the dealer's family, sometimes from a bondsman on retainer, sometimes from a clerk in the magistrate's office whose nephew worked the corners. The broker would call one of 2 prepaid cell phones Marcus kept in a desk drawer at the Avenue F office. He would give Marcus the name, the booking number, and the charging detective. Marcus would walk into the public defender's office the next morning and use the rotation system the way it was designed to be used. The office's case assignment software let senior attorneys flag specific cases as ones they wanted to handle. It existed for legitimate reasons: continuity of representation, expertise on specific charge types, conflicts of interest. Marcus used it to claim every Ensley crew case before another attorney in the rotation could touch it. He would visit the client once at the Jefferson County Jail. The visit averaged 11 minutes. He never filed a motion to suppress on any of those cases. He never demanded full discovery beyond the initial police report. He never investigated chain of custody on the seized narcotics. He never subpoenaed the confidential informant's file, even on cases where the informant had been the entire basis for probable cause. He gave them all the same speech. Investigators later interviewed 9 of his former clients, and 7 of them recited it back from memory. The case was unwinnable. The prosecutor's offer was the best they would ever see. Going to trial would triple their exposure, and cooperating with the government, talking to the DEA, naming names, would get them killed inside. That last line was the lock. Every one of these clients was a young man from the same West Side neighborhoods, who knew exactly which families the Ensley crew controlled and exactly what happened inside Donaldson or Holman to defendants who cooperated. When their own lawyer, the man whose job they understood was to fight for them, told them that any cooperation deal was a death sentence, they signed the plea. They pled, on average, to enhanced trafficking counts that prosecutors had not expected to land. They pled without ever knowing about the Fourth Amendment issues, the identification problems, the lab certifications. They pled at a rate of 96% against an office average of 71%. The U.S. Attorney's Office would later determine that at least 22 of his Ensley-connected clients received sentences 3 or more years longer than the office baseline for comparable charges. The envelopes came twice a month, $5,000, sometimes 8, sometimes 12. Cash, mostly, gift cards occasionally. Visa prepaids, Apple Store, Home Depot. Marcus's wife noticed nothing. His co-workers noticed nothing. His evaluations through 2023 continued to praise his remarkable efficiency in moving cases to resolution. Stories like this one do not get covered the way they should. The local news ran a paragraph and moved on. If you want to see more accountability content like this, subscribe and hit the notification bell. We are heading into the wiretap that broke this case open next, and the way it broke open is going to surprise you. In May of 2024, none of this had anything to do with Marcus Hollings. The DEA's Birmingham Field Division had been running a Title III wiretap on the Ensley crew's logistics broker for 14 weeks. The wiretap had nothing to do with the public defender's office. It had been authorized to capture conversations about a shipment of pressed fentanyl pills coming up from the Texas-Mexico border through Atlanta. The agents listening were narcotics investigators. They were not looking for a lawyer. On May 14, 2024, at 9:47 in the evening, the broker placed a call to an upstream supplier in Houston. The conversation went on for 19 minutes and covered 3 different topics. Most of it was about a load of pressed pills that had been intercepted in northern Mississippi the week before and how to absorb the loss. Near the end of the call, the broker mentioned that he was going to need to move some money around at the end of the month because, in his words, the lawyer's price is going up again. The supplier asked which lawyer. The broker said, Marcus, the D one, the public defender on the kids' cases, Marcus D. The DEA agent monitoring the call stopped the recording, ran it back twice, and flagged it to his supervisor that night. The supervisor flagged it to the U.S. Attorney's Office for the Northern District of Alabama the following morning. By the end of the week, a parallel honest services investigation had been opened, and a federal prosecutor named Renata Chen had been assigned to run it. What Chen did first was the simplest investigative move available to her. She pulled the entire felony narcotics caseload of the Jefferson County Public Defender's Office for the previous 5 years. She separated out the cases handled by the 4 senior felony attorneys, and she ran a statistical comparison. The 3 attorneys other than Marcus showed broadly similar patterns. Plea rates between 68 and 74%. Suppression motions filed on roughly 40% of drug cases. Sentence outcomes that tracked predictable variance based on charge type, criminal history, and quantity. The numbers behaved like normal numbers. Marcus's numbers did not. His plea rate across his entire caseload was 81%, high, but not impossible to explain. The anomaly was inside that number. When Chen separated his Ensley Crew-affiliated clients from the rest of his clients, the picture changed completely. On his non-Ensley cases, his plea rate was 73%, and his suppression motion rate was 38%, almost exactly what his colleagues showed. On his Ensley cases, his plea rate was 96%, and he had filed exactly 0 motions to suppress in 5 years. The same lawyer, doing 2 different jobs, depending on who his client was working for. That divergence was the entire case in one chart. Chen later told the jury that when she saw the printout, she knew she had him. The investigation took 5 months from the May wiretap call to the search warrant. In June, federal agents began surveilling the Avenue F office. They watched Marcus arrive on Tuesdays and Fridays at roughly the same time, between 4:30 and 5 in the afternoon, after his court calendar at the Mel Bailey Center had wrapped. They watched a man they would later identify as a mid-tier Ensley Crew lieutenant enter the building twice that month, both times within 20 minutes of Marcus's arrival, both times carrying a small canvas tote. In July, they pulled financial records. They found approximately $190,000 in unexplained cash deposits spread across 3 personal accounts and a shell LLC registered to his mother-in-law's address in Bessemer. The LLC, called Hollings Estate Holdings, had no employees, no assets, and no legitimate income. It had been formed in February of 2019. Its only activity was depositing cash and paying for renovations on the Crestwood house, 2 used SUVs, and a 6-month timeshare in Destin, Florida. In August, Chen subpoenaed the records of the prepaid cell phones the broker had been using. 2 of those phones had been activated at a Walmart in Bessemer in late 2018 and had contacted only 1 outside number with any regularity, a second prepaid phone whose location data placed it inside the Avenue F office during every business day of the relevant period. In September, investigators interviewed 3 of Marcus's former clients in federal custody. 2 of them refused to talk. The third, a 24-year-old named Devin Reese, who had pled in February of 2021 to a charge his arrest record showed, had a textbook Fourth Amendment defect, recited the speech Marcus had given him, almost word for word. Reese was serving 11 years at Yazoo City. He had been 19 years old when Marcus walked him into that plea. The investigation also surfaced two other named incidents that became central to the indictment. In August of 2022, Marcus had represented a 22-year-old client identified in court records as J.M., a young man who had been identified solely by a confidential informant whose prior testimony had been thrown out in two other Jefferson County cases. Marcus had declined to subpoena that informant's file. He had advised the plea. The client had received 9 years. In November of 2023, a 31-year-old client identified as T.W., the only one of Marcus's Ensley-connected clients to refuse the plea and insist on trial, had watched Marcus withdraw, citing a conflict 3 weeks before the trial date, leaving replacement counsel scrambling to learn the file. T.W. had been convicted at trial and sentenced to 17 years. In October of 2024, a magistrate judge in the Northern District of Alabama signed 3 search warrants, one for the Crestwood House, one for Marcus's office at the Mel Bailey Center, and one for the second-floor walk-up at 1417 Avenue F. The Crestwood search turned up financial records, a laptop, and a small amount of cash in a bedroom safe. The Mel Bailey office search turned up almost nothing. Marcus had been careful never to keep anything connected to the scheme inside the public defender's building. The Avenue F search turned up everything. In the bottom drawer of the desk, agents found the 2 prepaid cell phones, both still active, both with text histories going back to 2021. The texts were short and largely coded, but a forensic linguist would later testify that the pattern of communication, the timing of messages relative to arrest dates pulled from court records, the dollar figures, the references to client initials, was consistent with a recurring transactional relationship. On the desk itself sat a souvenir Vulcan statuette, a small bronze-painted casting of Birmingham's Iron God landmark that Marcus had bought as a tourist trinket years before. The agent who picked it up noticed it was heavier than it should have been, and that the base unscrewed. Inside the hollow base, vacuum-sealed in 4 flat plastic packets, was $61,400 in cash. And in the top drawer of the same desk, inside an unmarked black notebook, was the ledger. The ledger was 3 pages long. It was written entirely in green ink, in Marcus Hollings' own handwriting, a fact confirmed by a forensic document examiner who compared the writing to Marcus's signed plea agreements filed in dozens of cases over the previous 5 years. The left column held client initials. The middle column held dollar figures. The right column held plea outcomes. 120 MOs, 108 MOs, 144 MOs, written in the same crisp shorthand he used on his case notes. 22 entries, 22 clients, $22 figures, 22 sentences. The same hand that had signed every plea agreement had written down what each plea was worth. When federal prosecutors later showed the ledger to a panel of 3 former public defenders who had been asked to review the case, one of them, a woman who had spent 26 years doing the work, set the document down and did not pick it up again. The arrest happened on the morning of October 30th, 2024, on the front steps of the Mel Bailey Criminal Justice Center, 10 minutes before Marcus was scheduled to appear at a 9:00 a.m. status conference for an unrelated case. 2 FBI agents and 1 investigator from the U.S. Attorney's Office approached him as he came up the steps holding his briefcase and a paper coffee cup from the courthouse cafeteria. Body cam footage from the lead agent captured the conversation. "Mr. Hollings, Marcus Hollings." "Yes, sir, I'm Special Agent Louis Paget with the FBI. This is Agent Vasquez. We have a federal arrest warrant for you. I need you to set the briefcase down on the step, please. What is this regarding? Honest services wire fraud? Conspiracy to distribute controlled substances? Money laundering? The warrant is signed. I need you to set the briefcase down, sir. There's been a mistake. We can talk about that downtown. Please set the briefcase down. I have a court appearance in 9 minutes. There are people inside this building who can clear this up. I have a status conference in courtroom 504. I understand, sir. Someone will be notified. Please set the briefcase down and put your hands behind your back." Marcus did not move for a moment. The body cam footage shows him looking up at the front of the courthouse, the same building where he had argued his first jury trial, where his name was on the door of an office on the 4th floor, where his colleagues were at that moment walking past the front steps on their way in. He set the briefcase down. He did not ask for a lawyer. He did not say anything else. He put his hands behind his back and stood there on the steps in a charcoal suit while Agent Vasquez closed the cuffs around his wrists. A clerk from the misdemeanor division, walking in for her shift, later told investigators that she had recognized him from the back as she came up the steps and waved before she realized what she was seeing. The federal grand jury returned the indictment that same afternoon, October 30th, 2024. The charges were sweeping. 1 count of conspiracy to commit honest services wire fraud under 18 U.S.C, sections 1343, 1346, and 1349. 6 substantive counts of honest services wire fraud. 1 count of conspiracy to distribute controlled substances under 21 U.S.C. section 846, on a theory that knowingly facilitating the organization's protection from cooperator testimony made him a member of the conspiracy itself. And 3 counts of money laundering under 18 U.S.C. section 1956. Marcus retained a respected white-collar defense attorney out of Atlanta named Owen Bromfield. Bromfield filed every motion the file would support. He moved to suppress the contents of the Avenue F search, arguing the affidavit relied on unverified informant tips. He moved to sever the drug conspiracy count from the wire fraud counts. He moved to exclude the green ink ledger on the grounds that the document examiner's methodology had not been properly Daubert vetted. Judge Lillian Avery Hartwell, a 2014 Obama appointee with a background in white-collar prosecution before her appointment, denied every motion in turn. The ledger came in. The trial began on November 17, 2025, and lasted 3 weeks. The government called 41 witnesses. The DEA agent who had monitored the May wiretap call played the recording for the jury. The forensic accountant walked them through the cash deposits, the Shell LLC, the Bessemer address. The document examiner testified about the green ink. 3 of Marcus's former clients, including Devin Reese, brought up from Yazoo City in a federal transport, testified about the speech, the 11-minute jail visits, the silence on suppression. The defense called 4 witnesses, including Marcus himself. He testified for 2 days. He denied taking money. He denied recognizing the ledger. He acknowledged the Avenue F office, but described it the way he had described it to his wife, a quiet place to read transcripts. On cross-examination, Prosecutor Renata Chen handed him the ledger and asked him to compare the handwriting to a plea agreement he had signed in 2022. He looked at it for a long time before he answered. The jury was watching him when he did. On December 4th, 2025, after 11 hours of deliberation, the jury returned guilty verdicts on all 11 counts. Sentencing was held on February 11th, 2026. The courtroom was full. 3 of Marcus's former clients, released or on supervised release, sat in the gallery. So did 7 attorneys from the Jefferson County Public Defender's Office, including the office director, who had asked to be there in person. The director read a victim impact statement on behalf of the office. She spoke for 9 minutes. She said that the harm Marcus had done was not measurable in dollars and could not be undone by restitution. She said that every public defender in that building would carry the weight of his choices for the rest of their careers, because every client they ever represented would now wonder, on some level, whether the lawyer in front of them could be bought. She said the work was hard enough before. She said it was harder now. Devin Reese spoke for himself. He was 24 years old. He read from a piece of paper. He said that when he was 19 and sitting in a jail cell in Birmingham, the man who came to see him was the only person in the world he believed was on his side. He said he had signed his life away in that visit. He said he wanted Marcus to know that he had spent 4 years in federal prison thinking about him. Judge Hartwell spoke last. She addressed Marcus directly from the bench, and her statement was later reproduced in full by the Alabama State Bar in the order of permanent disbarment. Mr. Vades, Hollings, the constitutional system of indigent defense exists because the founders of this country understood that the power of the state to deprive a citizen of liberty is the most dangerous power government holds, and that it must be checked by an advocate of equal standing. You took that chair. You swore an oath to sit in it, and you sold it for $16,000 a month. Every client who placed his life in your hands had less protection from the state than a man who refused counsel altogether and stood mute. You did not just betray those clients. You betrayed every defender in this district who does this work for the right reasons and who now has to convince a skeptical client that they are different from you. The court finds your conduct among the most serious breaches of legal ethics it has ever been asked to address. The sentence will reflect that. The sentence was 17 years in federal prison, designated to FCI Talladega, $342,500 in forfeiture, $1.2 million in restitution, to be paid into a fund administered by the Jefferson County Public Defender's Office for post-conviction review of his former clients, 5 years of supervised release, lifetime disbarment. Marcus turned 46 years old in federal custody 3 months later. As of this recording, his projected release date is in 2041. 22 of his former clients are still inside, reading the news about him from their bunks. The Post-Conviction Review Fund has, to date, identified 11 of those cases as candidates for sentence vacatur. The work is ongoing. The man who was supposed to stand between them and the machinery of the state will be 61 years old when he walks out of FCI Talladega. Some of them will still be inside when he does. This case was hard to sit with. But the case on the right-hand side of your screen, what that one lacks in scale, it makes up for in betrayal. Click it now.